मैं प्रवीण सिन्हा आप सबका स्वागत करता हूं अपने इस चैनल में। और मैं एक बार फिर से आप लोगों के बीच लेके आया हूं एक वेरी यूनिक केस जो अभी रिसेंट में दिल्ली हाई कोर्ट ने अपना जजमेंट दिया इसके ऊपर। एंड द टॉपिक इज डिले इन सैंक्शनिंग जीएसटी रिफंड बाय द जीएसटी अथॉरिटीज। सो लेट्स स्टार्ट that what was the case, who was the party, who was the party in the case, who has filed the case before the court. So let me ask you a practical GST question. Suppose your business has filed a GST refund application. All documents are submitted. Everything is correct, but a month passes and the refund is still not processed. Can GST department keep your refund pending it indefinitely? This exact issue came before the Delhi High Court in the case of IT Preneurs Technology Private Limited versus Joint Commissioner. Now let us understand what actually happened in the case. The taxpayer, that IT Entrepreneurs Technology Private Limited, filed a GST refund claim with the department. The company had complied with the procedural requirement and submitted a relevant documentation. However, despite the application being properly filed, the refund remained pending for a long time. So the taxpayer approached the Delhi High Court seeking direction against the delay. An Honorable High Court, to decide this matter, examined the provision of Central Goods and Services Tax Act 2017 and particularly Section 54. Section 54 basically deals with the refund of tax under GST. So now here is an important point. GST law does not merely allow taxpayer to file refund claims, it also creates a statutory framework for processing those claims within a statutory and reasonable timeline. So the most important question of law before the court was, can GST authorities keep refund application pending indefinitely despite the statutory framework provided under Section 54? Or in other way, is refund processing a discretion of GST department or is it a legal obligation of the department? So this question of law has been decided by the Honorable Delhi High Court, and Delhi High Court has examined the factual aspect of the case. What has been observed, what has been examined by the Delhi High Court? Number one, was the refund application properly filed? Number two, was refund application was filed within time? Were the required documents submitted? Was there any deficiency communicated by the department? And most importantly, how long had the refund remained pending? After reviewing all these things, all these points, the court found that the refund was pending without a sufficient justification, and court has given its observation. The court noted that the GST framework provides a structured mechanism for filing and processing the refund claims. GST department cannot keep it pending for a long time. If authorities keep refund claims pending indefinitely, it defeats the very objective of the GST system. So court has directly hit the objective of the GST system when our GST department itself delay in sanctioning the GST refund filed by the assessee. So it's defeat the very objective of the GST system or GST framework. The court also recognizes that delay refund can seriously impact the working capital of the businesses. So this is the very important and very vital observation of the Honorable High Court. This is a very true fact that if a GST refund is held by the GST department intentionally for a indefinite period, then the working capital of the business will directly impacted. If the business cash flow of the company will be held by the department, then how a business will operate its business, and for lack of the working capital, the businesses might collapse. So this is the responsibility of the GST department to file the refund, to sanction the refund claim within a reasonable time. So based on this observation, the court finally given its judgment on 10th February 2026. And what was the final judgment? Refund application must be processed within the statutory framework under Section 54 of the CGST Act. Tax authorities cannot indefinitely delay refund processing without valid legal justification. So what does this judgment mean for businesses? This decision reinforces that refund claim cannot be kept pending arbitrarily. Taxpayers have a legal right to timely refund processing. business can challenge a reasonable delay before the court. So now the practical question, what should business do? First, ensure refund application filed with complete documentation. Number 2, your refund application is filed within the reasonable time frame prescribed by the law. Number 3, keep on track on regular basis refund status on the GST portal. Number 4, if refunds are delayed, submit a follow-up representation before the concerned authority, and if concerned authority does not respond even after the representation, and then finally if the delay continues without justification, legal remedy can be considered. So the key takeaways from this judgment is very much simple. The refunds, GST refunds, are a statutory right of the businesses, not a matter of departmental discretion. Timely refund processing is very much essential for the smooth functioning of the business, and if the GST department sanctions the GST refunds on time, it will also meet the very objective of the GST department.